Hi, my name's attorney Casey Walker. I'm the founding attorney of VA Disability Group. Today we're going to discuss 1151 claims. So what is an 1151 claim? Well, it's really for additional harm caused by VA healthcare or the vocational rehabilitation program. It's a misunderstood benefit. It's one of those benefits that pays in addition to disability compensation. So let me read for you my opening statement as to what exactly an 1151 claim is. An 1151 claim, also known as a Section 1151 claim, is a specific type of VA disability claim filed under 38 U.S.C. 1151. This law allows veterans to seek additional compensation if they experience, and here's the kicker, a new disability or worsening of an existing disability due to VA healthcare or participation in a VA vocational rehabilitation program. So it's a mouthful, but as I started with, some type of additional disability or injury caused by VA healthcare or the vocational rehabilitation program. So the regulations we're going to be looking at today are 38 U.S.C. 1151. So this is one of those unique situations where the common term associated with the benefit comes straight from the statute, which is Section 1151 in the statute. Usually VA benefits are referencing regulations, but here we're referencing an actual statute. So let's take a look at the 1151 statute. So this additional injury must be the direct result of VA care, and it must not be a reasonably expected result or outcome. And at least one of the following must also be true: VA carelessness or negligence, or VA medical or surgical treatment, or VA health exam, or a VA vocational rehabilitation course, or a VA compensated work therapy program. So really what they're getting at here is negligence by a VA healthcare provider. So let's say you go in for a knee surgery and you're service connected for that knee, and while you're getting the surgery you have some type of permanent impairment to a nerve in your knee. That would be not an expected outcome, so you could file an 1151 claim for the nerve damage because of your service-connected surgical operation on your knee. Another example might be if you had temporomandibular joint dysfunction, and let's say they do some type of surgical operation to help repair your jaw issue, and they hit your 7th facial cranial nerve and you develop some type of facial paralysis. Yet again, that's not a reasonably expected outcome. You could file for an 1151 claim in that regard. So we're talking negligence here, and this isn't filed with the federal government judicial system. This is filed directly with the administrative government, which is the Department of Veteran Affairs. The form that you're going to use to file an 1151 claim is the exact same form that you use for a disability compensation claim. It's a 21-526EZ. Well, let's take a look at that form. If you go down to page 10, you'll notice that there's a section that expressly references the 1151. This is in section 5 on page 10 in the notes right above where you add the claims. It actually lists 1151 claims. So below that, where you're actually going to file the specific claim that you've been harmed for or harmed with, it asks you to provide an explanation as to how that harm happened on active duty. That really doesn't apply here because we're not on active duty anymore, but what you're going to do there is you're going to write see attached statement /1151. And then at the top of the 526 form, I also want you to write 1151 claim. You want to guide, you want to drive the claim. You don't want the adjudicator to pick it up and to treat it like a disability compensation claim. This is an 1151 claim for some type of negligence by a healthcare provider. So as long as you ensure that they are aware that you're filing an 1151 claim. Now what you're also going to do is you're going to take a VA form 21-4138. Use this form because it's got a certification statement at the bottom, and the VA employees are used to their own forms. And it's just a standard blank form for you to write a statement. On that form, you're going to write the who, what, where, when, and why. What was the surgery for? You essentially want to get to the elements of an 1151 claim. What was the harm done? Why was it not a reasonable expected outcome? And what was the negligence? Like, what did the doctor do wrong? If they hit a nerve that they shouldn't have hit, or if they operated on the wrong limb, or whatever it might be, if they prescribed the wrong medication, if they gave you some type of shot of a known allergy that you have, and you reacted, whatever the negligence is, spell it out. Spell it out in detail. The more specific, the better. And you're going to take that 4138 form and you're going to append it or attach it to the 21-526EZ. Then you're going to send that application to the Evidence Intake Center or wherever the form says, because in a year they might change where you have to submit the application. Once that happens, these things can take a while. These are a little bit out of the normal streamline, so I'd say expect 1 to 2 years. Sometimes there's a little bit of development that happens in the background. It's a little strange, but the VA medical facility will actually contract with another individual to provide an opinion as to whether the other VA employee was negligent. As you could imagine, VA health providers don't like to throw other VA health providers under the bus. So there tends to be a high denial rate of 1151 claims. But if you have a strong case, I strongly encourage you to pursue these. We'll get into the host of reasons that you should pursue these and the additional benefits that can accompany 1151 claims and the unique considerations at the end of this. But let's step back one more time and let's walk through the elements of an 1151 claim. Again, you have to have a new or worsened disability. And that disability was not reasonably expected, and at least one of these must have led directly to an added disability. And we got into it, the VA carelessness or negligence, or VA medical or surgical treatment, or VA health exam, or vocational rehabilitation incidents, or VA compensated work therapy. So those are the elements. You have to meet them. So in your statement on the 4138 form, address those elements in addition to the who, what, where, when, why. So let's talk about some of the other considerations that are unique to 1151 claims. It's not disability compensation. So why is that relevant? Because you can double dip. You can receive the totality of your disability compensation while also receiving compensation under an 1151 claim. So it's rare that the VA allows veterans to double dip in these instances. So that's one you'll want to avail yourself to if you have had a genuine 1151 harm done to you. There's no statute of limitations. So that's similar to VA disability compensation claims. But if you're harmed by a medical provider within the VA healthcare system, 12 years later, you can still file that claim. Now, gathering the evidence might be difficult, but there's no statute of limitations, which is another way of saying there's no deadline to file that claim. Now, compare that to the Federal Torts Claims Act. So let's talk about the Federal Torts Claim Act for a little bit. The Federal Torts Claim Act is a mechanism where individuals can sue the U.S. government, which would include the Department of Veteran Affairs. The statute of limitation does apply to FTCA claims. It does not apply to 1151 claims. Now, if you're going to file an 1151 claim correctly, you should probably file both an 1151 claim and an FTCA claim contemporaneous with one another. Now keep in mind again that the statute of limitations might have already ran on the FTCA claim, which would only leave you with the 1151 claim. The FTCA, if you're successful on the 1151 and the FTCA claim, those will offset each other because you're being compensated for the same harm twice. So you can double dip VA disability compensation and the 1151 claim. You cannot double dip an FTCA claim and an 1151 claim. The FTCA claims can be complex. It's a heightened burden to show that there is gross negligence. There's a heightened burden to demonstrate that there is something egregious happened. So there's even a higher denial rate under the FTCA claims. So a lot of veterans choose just to pursue the 1151 claims. No home loan guarantees. So if you are awarded compensation for an 1151 claim, there will not be a home loan guarantee. The Federal Circuit Court decided that this was outside the scope or the purview of the home loan guarantee program. However, specially adapted housing grants and automobile and adaptive equipment grants, those are within the scope of 1151 harmed claimants. So if you are successful in your 1151 claim, you can avail yourself to those ancillary programs. One question we get a lot is, I was using a third-party contracted healthcare provider through the Mission Act. Sometimes they refer to this as a Veterans Choice Program. It's where the VA might be overwhelmed and have long waits, so they send you out to a private medical provider in the community. Well, this isn't a VA healthcare provider, and if you look at the statute, the harm must come directly from the actions of a VA healthcare provider. And so in most instances, you're going to have a difficult time claiming an 1151 claim if the harm stems from a third-party contracted provider. In this instance, what we usually recommend people do is seek a private malpractice lawsuit against that provider if the facts warrant such. But it's going to be difficult for you to claim the 1151 claim against the Department of Veteran Affairs for harm done by a third-party contracted provider. So that's the summary of 1151 claims. There's a lot to them. They can be complex, and it involves multiple healthcare providers providing opinions about malpractice or negligence to a certain extent. Medical providers can get quite upset about these types of claims. So if you have a good relationship with your healthcare provider within the VA system, keep in mind this might really put a dent in that relationship if you're trying to claim that they committed negligence against you. It doesn't usually come directly out of their pockets and affect them directly, but they don't like it at all because it involves them and questionnaires that they get. Those are really all the unique considerations. So I hope you enjoyed this video, and if you did, like and subscribe to the channel. You'll find a host of links in the description below. Thanks. Have a great day.